Hi everyone, this is Devika Sharma, and in this week's SCC Online Weekly Rewind episode, I'm going to bring you some of the very insightful legal updates. So stay tuned. Let's have a look at the top story of this week. Noting the fact that a man suppressed the material fact of his private life before marriage, that is about him being a homosexual, Thane Court found that the whole life of a young girl had been spoiled due to the material suppression. If the same would have been shared prior to the marriage, then the consequence would be different. Bench expressed that, no doubt, every individual has its dignity to live in the society. No other person can interfere into lifestyle, but that does not mean that a person gets liberty to spoil the life of either of the spouse. Let's have a look at the updates from the Supreme Court. In a very interesting case where the husband had disputed paternity of child on suspicion, though the Supreme Court has allowed the DNA test, it has also granted a conditional compensation of 30 lakhs to the wife if the suspicion proves to be wrong and husband turns out to be the father of the child. The couple got married on 5th Feb 2014 and the marriage was consummated on 9th Feb 2014. The child was born after 261 days, that is about 17 days earlier, which was almost after 9 months. Therefore, the wife had contended that there was no reason to presume that the petitioner was pregnant when she married the respondent. Before the Supreme Court, the Bombay High Court had also directed the DNA test. In the 2006 Meerut Fire case, the Supreme Court has held the organizers responsible for the incident and not the contractor, as the contractor was only responsible for executing work as assigned to him by the organizers. The victims can finally see some ray of hope after 16 years of the unfortunate incident that claimed 65 lives and left 161 or more with burnt injuries, as the Supreme Court has now directed the Chief Justice of the Allahabad High Court to entrust the work of determination of compensation to a judicial officer in the rank of district judge at Meerut within 2 weeks of the present order to work exclusively on the question of determination of the compensation on day-to-day basis. Now let's see some of the interesting updates from the High Courts. With the absence of a president of state commission or district forum for reasons beyond control is sufficient for striking down Section 29A of Consumer Protection Act as unconstitutional, stating that the courts cannot examine the constitutional validity if a situation created by the impugned legislation is irremediable. The division bench of the Bombay High Court addressed a matter wherein the constitutional validity of Section 29A of the Consumer Protection Act was challenged. High Court observed that the language of Section 29A of the Consumer Protection Act is intended to provide for a situation where a president of state commission or district forum is non-functional, either having not been appointed in time or is on leave due to reasons beyond his control. The scheme of appointment and adjudication of consumer disputes is laid down under the Act to make the district forum or state commission continuously functional, allowing the members in the absence of the president to function in a situation beyond the control of the members of the forum. To read the full report on this very interesting case, please check out the SCC online blog. Stating that it is the duty of every advocate to uphold professional integrity so that citizens can legally secure justice, the division bench of the Bombay High Court expressed that professional misconduct refers to its disgraceful conduct not befitting the profession concerning the legal profession, which is not a business or trade, and therefore it must remain decontaminated. In this case, the court was perturbed by the act of the advocate to keep valuable security owned by the client with him. Bench also observed that The advocates owe a social obligation to the society while discharging professional services to the litigant. Advocate should not commit any act by which a litigant could be deprived of his statutory and constitutional rights on account of the sublime position conferred upon him under the judicial system in the country. Expressing that matrimonial cases are matters of delicate human and emotional relationship, the Division Bench of Punjab and Haryana High Court expressed that the court no doubt should seriously make an endeavour to reconcile the parties, yet if it is found that the breakdown is irreparable, then the divorce should not be withheld. The court remarked that the consequences of preservation in law of the unworkable marriage, which has long ceased to be effective, are bound to be a source of greater misery for the parties. Rajasthan High Court granted parole to a convict whose wife sought 15 days of emergent parole for want of progeny. High Court observed that having progeny for the purpose of preservation of lineage has been recognized through religious philosophies, the Indian culture, and various judicial pronouncements. The right of progeny can be performed by conjugal association. The same has an effect of normalizing the convict and also helps to alter the behavior of the convict prisoner. Expressing that a firm is not a legal entity, the Bombay High Court held that a partnership firm is only a collective or compendious name for all the partners. A partnership firm does not have any existence apart from its partners. Therefore, a decree in favor of or against the firm in the name of the firm has the same effect like a decree in favor of or against the partners. Hence, when a firm incurs a liability, it can be assumed that all the partners have incurred the liability, and so the partners remain liable jointly and severally for all the acts of the firm. Now let's move on to the legislation updates. Ministry of Finance notified Income Tax 8th Amendment Rule 2022 in order to amend the guidelines of Infrastructure Debt Fund in the parent rules of Income Tax Rules 1961. The 8th Amendment will be enforced with immediate effect. The amendment set up the Infrastructure Debt Fund as a non-banking financial company according to the conditions set by the Reserve Bank of India in the Infrastructure Debt Fund Non-Banking Financial Companies Reserve Bank Directions 2011. On 11th April 2022, Securities and Exchange Board of India issued Securities and Exchange Board of India Listing Obligations and Disclosure Requirements 3rd Amendment Regulations 2022. This regulation comes into effect with immediate effect and aims to replace asset cover with security cover for the listed debt with SEBI. Asset cover certificate is used to monitor the adequacy of assets charged against the debt obligations of the person issuing it. It is submitted to the debenture trustee. On April 12, 2022, the Department of Economic Affairs has issued the Foreign Exchange Management Non-Debt Instruments Amendment Rules 2022 to further amend the Foreign Exchange Management Non-Debt Instruments Rules 2019. The amendment modifies the period of convertible note from 5 years to 10 years. The central government notifies National Insurance Company Limited Merger Amendment Scheme 2022 to amend the National Insurance Company Limited Merger Scheme 1973. In the National Insurance Company Limited Merger Scheme 1973, the authorized share capital of 3 public sector general insurance companies has been enhanced from 7,500 crores divided into 750 crores to 15,000 crore divided into 1,500 crore. I hope you found the video meaningful, and this is Devika Sharma signing off for this week.